Welcome back to Car Accident Playbook. I'm Abby, and today I'm here with Lem Garcia from Lem Garcia Law. Good to have you back, Lem. Thanks for being here.
Oh, it's great to be here.
Today, we are talking about something almost everyone wonders after our crash in West Covina, but few people actually understand. When do you really need a lawyer, and how does a car accident lawyer get paid? We are going to walk through how to tell if your case needs an attorney, exactly how contingency fees and case costs work, and what a lawyer actually does day to day, how to choose the right one in San Gabriel Valley, and the deadlines that decide whether you have a case at all. If you have been hurt on the I-10, the I-605, or the SR-60, and you are not sure whether to call, this is the episode for you. So, getting into question one, a lot of people walk away from a crash unsure whether this is a phone call problem or a lawyer problem. So, after a crash in West Covina, how do you know if you actually need a lawyer?
A lot of people are surprised when I say this, but not every car accident needs a lawyer. In fact, sometimes people call us and I tell them they probably don't need us. If nobody's hurt and the insurance company is handling things fairly, you might be perfectly fine on your own. But there's a caveat, like where people get into trouble is when they're injured, when they're getting medical treatment, when they're missing work, or they're being offered money and they don't know what's fair. And the reason I say that is because we get way too many calls from people after they've already signed the release. And that's some of the toughest conversations start the same way. They say, hey, Lem, I think I made a mistake. The insurance company made me an offer. It sounded fair, and I took it. And then a few weeks later, they're still in pain. Maybe they're in physical therapy. Maybe their doctor wants an MRI. And that's when they decide to call a lawyer. But the problem is that they've already signed the release. And once that release is signed, the case is usually over. And if you're hurt, getting treatment, missing work, or thinking about a settlement, get a second set of eyes on it before you sign anything, because I'd rather spend 10 minutes reviewing an offer than have to tell someone that it's too late.
Some people figure a small fender bender with sore muscles is too minor to bother a lawyer with. Is it worth hiring a lawyer for a minor crash with small injuries?
It might be, but the first thing that I'd tell you is this: don't confuse a small dent on your car with a small case. A lot of people look at the damage at the car and assume that that's how much the case is worth, and it really doesn't. I've seen cars with barely a scratch on it, and that led to months of treatment. And I've seen cars that look terrible where the person was perfectly fine. The car tells part of the story, but your body really tells the rest. So when someone tells me it was a minor car accident, my next question is always the same: are you hurt? Because that's what really matters. If you're not hurt, you probably don't need a lawyer. But again, if you're getting treatment, missing work, it's worth taking a closer look. And that one mistake people make is assuming that a settlement offer must be fair because the crash did not look that serious. So they take the money, sign the release, and then move on. But then a few weeks later, they're still hurting. Maybe they're in physical therapy. Maybe their doctor wants an MRI. And now they're wondering whether they settled too soon. And unfortunately, once you've signed the release, it's over. I think the better question is, do I know enough to decide whether this offer is fair? And if the answer is no, just spend 10 minutes talking to a lawyer before you sign anything. I've never had someone call me and say, hey, Lem, I wish I talked to you later. It's always the other way around.
People assume they can just handle the paperwork themselves and save the fee. What can a lawyer do that an injured person cannot do on their own?
The biggest thing a lawyer does is help you avoid expensive mistakes. Because if we're being honest, most of the things involved in an injury claim don't require a law degree. You can call the insurance company, send in medical records, negotiate, and even settle your own case. But the problem is that most people have never even handled an injury claim before, and the insurance company handles them day in and day out every day. Let's say they offer you $15,000. Is that a good offer? Is it a bad offer? And most people, they have no idea. And quite frankly, why would they? They don't know what cases settle for. They don't know why they're being asked to settle before they've gotten medical treatment. And we see that all the time. Someone starts feeling a little bit better, gets an offer, and then they take it. Then a few months later, they're still in pain, getting more treatment, and wondering if they settled too soon. And that's why I tell people anybody can settle a case. The hard part is knowing whether you should. And that's the lawyer's job, is to gather the evidence, evaluate the claim, and help you make decisions with all the information instead of guessing what's right or wrong. So does every case need a lawyer? No. But when the injuries are serious or fault is disputed or meaningful money is really involved, having someone who does this every day can make a real difference. Because at the end of the day, the insurance company already knows the rules. And the question is, do you know the rules?
Some people try to handle it themselves first and only think about a lawyer once things go sideways. When is it usually too late to bring a lawyer into a case?
Most of the time, it's not too late to bring in a lawyer. But keep in mind, the longer you wait, the fewer options you usually have. People call me and they say, hey, I should have called you 6 months ago. Maybe not. I think that the bigger question is, what happened while you were waiting? Because time doesn't just run off the clock. Time takes evidence with it. Witnesses forget details, security footage gets deleted, evidence disappears, and the longer you wait, the harder it becomes to prove your case. What worries me the most isn't when someone waits a month. It's when someone makes a major decision before getting any advice at all. One of my least favorite phone calls starts with, hey, Lemmy, I already signed the release, and that's really hard for me to hear. Because once someone signs a release, accepts settlement, the case is over. What I tell people is this: the worst time to ask for legal advice is after you made that legal decision. There's also deadlines, and if you wait too long to file suit, you could lose all your rights together. Just because you have time doesn't mean you should use all of it. The best time to talk to a lawyer is before making important decisions are made and before evidence starts disappearing, because we lawyers are much better at preventing problems than fixing them. And after years of doing this, I've learned something. I've learned that the cases that keep me up at night aren't usually the ones that come in too early. They're the ones that they came in a little too late.
So the short version is that the question is less about how dramatic the crash looked and more about injury, fault, and timing. Let's get into the part everyone really wants to understand: how a lawyer actually gets paid. So most people have heard the phrase no win, no fee, but have never had it explained. So what does a contingency fee mean for the client?
A contingency fee means that the lawyer only gets paid if the client gets paid. And if you think about it, that's a pretty unusual arrangement. Most businesses get paid whether the outcome is good or bad. And that's not how most or all personal injury lawyers work out. They don't work that way. A lawyer can spend months or even years working on a case and then not earn a fee unless there's a recovery. So we have to keep in mind that in a contingency fee case, the lawyer is taking a risk as well. And that's one reason personal injury law is available to so many people. Most accident victims, they don't want to write a check to get started, especially when they're already dealing with a direct car, medical bills, missing work, and everything else that comes along with getting injured in a car accident. That doesn't mean that us lawyers take every case, because we're only paid if the case succeeds, and we're typically very selective about the cases that we accept because we want to make sure that our work will get paid ultimately in the end. If a case is worth fighting for, then absolutely we would take it. What I think the easiest way to understand a contingency fee is that the lawyer does not get paid because they worked hard. The lawyer gets paid because they got a result. Or to put it another way, we're in a contingency fee, we shift a big part of the financial risk from the client to the lawyer.
This is the fear that stops a lot of people from even calling. If you lose, do you owe the lawyer anything then?
That's a really important question. I think not all contingency fee agreements are the same. A lot of people hear no recovery, no fee, and they assume that means they can't owe anything if the case doesn't work out. Sometimes that's true and sometimes it isn't. It depends on the firm. At Lem Garcia Law, if we don't recover money for the client doesn't owe us anything for fees or case costs. And that's not the same at all firms. At my office, we take the risk 100% and the client doesn't. So it's really important to read the agreement and ask questions before you begin and understand that there's case costs involved for medical records, filing fees, expert witnesses, and so on. And some firms will seek reimbursement of those costs even if there is no recovery. And that's a big distinction. That's not how we operate. And I think, if a client truly believes in a case, the client shouldn't have to worry about a bill at the end if, things don't go as planned. We take the risk, we share in the upside, but we're also willing to share the risk. So, when you're talking to a lawyer, don't just ask about what percentage they charge. Ask, if we lose, do I owe you anything? It's a simple question, but that answer can make a huge difference. And at my firm, Lem Garcia Law, the answer is, if we don't win, you don't pay.
And some people worry that the lawyer walks away with more than the injured person does. Can the fee ever end up larger than what the client takes home?
When people hire a lawyer, they usually focus on the fee percentage, but that's not the most important number. The important number is really what ends up in your pocket. And at Lem Garcia Law, this is our rule that our fee will never be more than the amount that the client takes home. Attorney's fees, they're not the only deductions that can come out of a settlement. There's also medical bills and case costs that need to get paid. So that's why I encourage people to look at the entire picture, not just a fee percentage, because a case can settle for a certain amount on paper, but what really matters is how much the client receives at the end. It's not about what the case settles for. Again, it's about what you keep. Make sure you understand how fees, costs, and medical bills will affect your recovery, because at the end of the day, that's the matter that matters the most.
Yeah, you mentioned this fee percentage, and people hear that and assume that it's only the deduction. But what costs come out of a settlement besides lawyers' fees?
And a lot of people think that the only deduction is the attorney's fee, and that's usually not the case. There's also case costs, and case costs, that's the expenses incurred while you're building and pursuing the case, like medical records, filing a suit, taking depositions, hiring witnesses or hiring expert witnesses, paying court fees if the case is getting litigated. And you should think of it like this. The fee pays the lawyer and the costs pay for the case. Not every case has significant costs. Many cases resolve without a lawsuit, and the costs are relatively modest, usually just for like medical bills and a police report, maybe a couple $100s total. But again, if a case becomes complicated, then those expenses can really add up. That's why I encourage people to ask two questions: what's the fee and what costs might come out of the settlement? And those two things they're not the same thing.
And you mentioned this before, but how do medical liens and the fee interact when the case resolves?
One of the biggest surprises for clients is that there might be more than one person getting paid from the settlement. If your health insurance paid for treatment, if Medicare or Medi-Cal paid for bills, or if a doctor agreed to treat you on a lien, they have a right to get reimbursed from the recovery. And that's essentially what a lien is. A lien is basically someone saying, we paid for your treatment, and if your case settles, we deserve to get paid back. That doesn't mean every dollar has to be paid without question. Part of our job as lawyers is to review those liens and then, when possible, negotiate those liens down. Because every dollar that goes toward a lien, that's a dollar that doesn't go to our client. And we've had cases where, reducing a lien puts thousands of dollars into the client's pocket. Every dollar that we get the medical provider to reduce, that's another dollar to the client. So that's very important to us. Again, what matters is what happens after the settlement check arrives, the attorney fee, the costs, the liens, all those things matter. But ultimately, in the end, it's how much is the client taking home at the end. And that's really what's important to us.
Yeah, once you understand that the fee is tied to your recovery and your net is what actually matters, the natural next question is what you are actually buying. So let's talk about what a lawyer does day to day on your case. People assume fault is obvious and already decided by the time they call, but how does a lawyer investigate who was really at fault?
Yeah, most people do think that fault is always obvious. And quite frankly, sometimes it is, and sometimes it isn't. We've seen cases where both drivers swear that they both had the green light. I've seen cases where the police report, they get it wrong. And we've seen cases where the most important piece of evidence didn't even show up until months later. And that's why a lawyer, we can't just assume that we know what happened. A good investigation needs to occur, and that starts with one question: how do we prove it? And that we start thinking about getting a police report, talking to witnesses, reviewing photographs, inspecting vehicle damage, or even tracking down surveillance video. And sometimes the smallest detail, they end up making the biggest difference. A witness, a photograph, security camera. So the goal isn't really to tell the best story. The goal is to prove the true story, because at the end of the day, fault is not determined by who is the most convincing. It's determined by the evidence. And that's why I tell people to preserve everything after a crash. Take photographs, get witness information, save text messages, keep anything that might help explain what happened. Because once that evidence disappears, it's gone for good. And when fault is being disputed, the side with the better evidence usually has the stronger case.
The adjuster calls keep coming, and people do not know what they're allowed to say. So, how does a lawyer deal with the insurance adjuster so the client doesn't have to?
A good lawyer doesn't just deal with the adjuster by arguing with them. A good lawyer, we deal with the adjuster by giving them a reason to pay. I think that's key. That's a very important distinction. A lot of people think that negotiating is about being aggressive, pounding the table, or making demands. And in reality, insurance companies, they don't write bigger checks because someone got loud or started yelling. They pay based on risk. The question the adjuster is asking is really simple: what happens if we don't pay this claim? And a lawyer's job is to answer that question with evidence: medical records, medical bills, lost wages, photographs, witness statements, anything that helps prove what happened and how the injury, and this is key, how the injury affected the client's life. Because this is what we've learned over the years, is that the strongest negotiation position isn't a strong opinion, it's strong evidence. The best settlements, they usually don't happen because someone made the perfect argument. They happen because the insurance company understands the risk of not settling the case.
Damages don't always just mean medical bills and car repair. So, what does it look like when a lawyer builds the damages side of a case?
The value of an injury isn't measured by what happened in the crash. It's really measured by what happens after the crash. The insurance company, they obviously they weren't in the car with you. They don't know what you're feeling. They don't know how much pain you're in or how the injury affected your life. They can only know what's proven, what we have documentation for. We have to keep in mind the insurance company, they don't just pay for injuries. They pay for injuries that are documented. That's why medical treatment, and we can't emphasize this enough, medical treatment is so important. If you're hurt, get the treatment you need, follow your doctor's advice, don't downplay your symptoms, and don't create long gaps in treatment if you're still having problems. Because if the record says, if they say you're doing fine, then that's the story that the insurance company, that's what they're going to believe. But medical records only tell part of the story. Medical records tell us what the injury is, and then you tell us what the injury cost you in your life. Can you still work out like you used to? Play with your kids, sleep through the night? Does your job, are you doing it the same way that you did before? And that's why, I recommend to clients that they keep a journal, nothing complicated, just, they just keep notes about what you're experiencing and how the injury is affecting, their day-to-day life. The goal isn't to create evidence. The goal is to get better. The evidence gets created along the way. And at the end of the day, the strongest cases don't just show that somebody got hurt. They show how that injury changed someone's life.
The word lawsuit makes people nervous, so they want to know when it actually happens. When and why would a lawyer take a case to court?
For clients that are or people that are getting nervous about trial or going to court, they need to know that most cases don't go to trial. Most cases don't even get filed. But we have to be able and willing to do that. And keep in mind that sometimes filing a lawsuit is the only way to get the insurance company to pay what the case is actually worth. At the end of the day, the decision really comes down to one question. Can we get the client more money by litigating the case? And if the answer is yes, then that's something that needs to get done, or at least be taken seriously, because lawsuits cost money, they take time, there's filing fees, depositions, expert witnesses, and nobody should file a lawsuit just to file a lawsuit. The reason you do it is because the insurance company isn't paying enough. We've had cases where the insurance company, their offer looked very different after a lawsuit was filed, and then after the evidence was fully developed. But that's why I tell people, insurance companies, they don't pay top dollar because you ask nicely. They pay top dollar when they have to. So the goal is not the lawsuit itself. The goal is maximizing the client's recovery. And our job is to make sure that the insurance company does not get away with paying less than they should.
Yeah, knowing what a lawyer does is half of it, and the other half is picking the right one and knowing what to ask before you sign. So let's get into that. Every billboard says the same thing, so people have no idea how to actually compare firms. What should you look for when choosing a personal injury attorney in the San Gabriel Valley?
Yeah, I would start with their reputation, not their advertising, not their billboards, their magazine ads, not their slogans, their reputation. What are former clients saying? Go online. What do their reviews look like? What are their Yelp reviews or Google reviews or any other website that has reviews? What are people saying about them? Are people talking about the firm in a positive light? Do they have good communication? Are they honest? Do they get good results, great results? Because after a while, you look at these reviews, clients, you start to see patterns emerge. And a firm's reputation, that's simply the sum of thousands of clients' experiences. So that's one thing. And then the second thing I'd look for is accessibility. When something important happens on your case, can you get an answer? Can you talk to the lawyer if you need to? Do you feel heard? A good lawyer doesn't just manage cases. A good lawyer manages relationships. So you want to make sure that you're able to speak with the lawyer. If you're calling someone on a magazine or a billboard, will you be able to talk to that person and get answers from that person? And then finally, you want a lawyer who's willing to do whatever it takes to give the client the best chance at a great outcome. That could be negotiating, that can be a lawsuit, that can be going to trial, that can be creating a team with other lawyers to get the best result possible. If you need someone with specialized experience, just whatever it takes to get the best result possible for the client. The best lawyers, we're not worried about who gets the credit for a case. We're focused on getting the best result for the client. Because at the end of the day, you have to remember that you're really trusting someone with a very important part of your life. Look for a lawyer with a strong reputation, who communicates well, and who puts the client's interests ahead of everything else. Results matter, but so does how you get there.
People assume every personal injury lawyer goes to court, but most never do. Why does it matter whether a firm is actually willing to go to trial?
Like I said before, most cases do settle, but I think here's what people, they don't realize. Cases are often settled in the shadow of a trial. What that means is the insurance company they're constantly evaluating one question. What happens if this case doesn't settle? If the answer is that this case could end up in front of a jury, go to trial, that matters a lot. Trial experience matters because it creates a lot of leverage. The insurance company knows that this firm has another gear that they can shift to. Now, does that mean every case should go to trial? No, I don't think so. Of course not. The goal isn't to go to trial. The goal, again, is to maximize the client's recovery. So if a case would benefit from additional trial resources, specialized expertise, clients should have access to that. The best result is more important than who gets the credit. And at the end, trial experience matters because it gives the insurance company a reason to really take the case seriously. And keep in mind that the best settlements often come from lawyers who are fully prepared not to settle.
And sometimes people sign the first agreement right in front of them without knowing what to probe. So what questions should someone ask before signing with a car accident lawyer?
Before you sign with a lawyer or law firm, you should really pay close attention to how does the consultation feel to you? Is the person listening to you? Are they answering your questions directly? Are they explaining things in a way that makes sense, avoiding legal jargon? They really want to communicate well with you to make sure that you understand the answers to your questions. Because ultimately, you're not just hiring someone to handle paperwork, you're hiring someone that you might be working for months or maybe even years. A good lawyer should make you feel informed and not confused. They should be clear about how the case works, how fees work, what challenges they see in your case, be upfront with those issues. And if you're leaving the consultation with more questions than answers, that's probably not good. That's telling you something. Just, I would say, at the end of the day, trust your instincts. If something doesn't feel right before you sign, don't assume that it'll feel better afterward. You're not choosing a lawyer, you're really choosing a relationship.
Some firms advertise guarantees, and people are just not sure if they are real. So, what does a no recovery guarantee or a cancellation guarantee mean?
I think for us, a no recovery guarantee means that if there's no recovery, there's no attorney's fee, and that includes costs. That's what it means to us. And yeah, if we take a reward, we should also take the risk. As far as the cancellation, we give clients a 30-day cancellation period. And the reason is simple. Not every relationship is going to fit right. So it's, if you figure that out early on, that for some reason, like our relationship is not right, you can cancel with us within 30 days and we're not going to charge you for anything. Even if you go to another lawyer and we did work on the case and they get a recovery for you, we won't charge you within that cancellation time. It's just really important to keep in mind that trust works both ways. If a client decides that within the first 30 days that we're not right for them, they can move on, no problem. And at the end of the day, these policies are really designed to just reduce risk for the client. After an accident, people, they have so much to worry about, and they shouldn't have to worry about getting stuck with attorney's fees or costs if their case doesn't go well.
Yeah, picking the right lawyer matters, but so does picking the right moment to call. So let's talk timing and deadlines because this is where good cases quietly die. So people figure they should wait until they are done getting treated before they call anyone. How soon after a crash should someone talk to a lawyer?
The sooner the better. It's never too soon after an accident to call a lawyer to help you out. And not because every case needs a lawyer. I think a lot don't. I think the reason is because that important decisions in your case get made very early on. People give statements, they sign documents, they might even accept the settlement offer. They get rid of evidence, they throw away photographs, they post things online on social media. They don't contact witnesses or they lose contact with witnesses. So a lot of big decisions happen very early on, and a good lawyer will help make sure that you make the right decisions at the very start, which is when a lot of the best decisions are made. Because, a lot of times when some of those bad things happen, they can really be difficult or even impossible to undo. Once a bell is rung, you can't unring it. The best time to get advice is before you need to do damage control. That doesn't mean the same day as an accident. That's when the accident happens, but I don't think that hurts. I do think that it's smart to have a conversation if you're injured, you're getting treatment, missing work. That's really important. Get a conversation going with an attorney. Case consultations are free and shouldn't be without any obligation at all. Because I've learned that in cases, the biggest mistake usually happens at the beginning of the case and not at the end. So you need to speak to a lawyer. A 10-minute conversation today can really prevent a $10,000 mistake tomorrow.
Most people have no idea that there is a hard deadline ticking from the day of the crash, too. So, what is the filing deadline for a California car accident case, and what happens if it passes?
Yeah, a lot of people know there's a deadline to file a lawsuit. What they don't realize is that waiting until the deadline that's a horrible strategy. In California, the deadline for most personal injury cases is 2 years from the date of the accident. There's some exceptions, and some deadlines can be much shorter. But the bigger point is that just because you have time does not mean you should use all of it. I've never heard a client call me and say, I wish I started my case later. It's, of course, the opposite, because when time passes, evidence disappears, witnesses forget details, photographs get lost, video footage gets erased. The deadline isn't the problem. What disappears before the deadline, that's the problem. And that's why I tell people not to focus on the calendar. Focus on protecting the evidence and getting the information that you need. The sooner that happens, the better it is for your case. Because if you miss the filing deadline, you can lose your right to pursue the case altogether. And that's a mistake that no lawyer can fix. So the best cases don't start when the deadline is approaching. They start while the evidence is still fresh.
Sometimes people assume that the evidence will just be there whenever they get around to it. But why does waiting to hire a lawyer make a case harder to win?
Again, it's because evidence, it has an expiration date. A lot of people think that waiting only matters because of the filing deadline. And that's part of it, but that's not usually the biggest problem. Time doesn't just run off the clock. Time takes evidence with it. Witnesses forget the details, footage gets deleted, photographs get lost. And if you're injured, then you get gaps in treatment, and that creates questions that didn't need to be there in the first place. Insurance company may ask, if you were really hurt, why did you wait 3 months to see a doctor? Or if your symptoms were ongoing, why did treatment suddenly stop? Yeah, that's why I tell clients to focus on their health, get the treatment, follow the doctor's advice. And if you're still having symptoms, don't just hope they'll go away, because the best evidence is created while you're getting better.
And if the other driver's adjuster calls and asks for a quick recorded statement, then they might sound friendly about it, but should you give the other driver's insurance company a recorded statement?
Yeah, my answer or my advice to this is really simple. No, don't give the other driver's insurance company a recorded statement, and at least not before speaking with a lawyer. The other driver's insurance company, they're not calling to help you build your case. They're not, or your claim. They're conducting an investigation. They're conducting an investigation to find a way to deny your claim, delay payment, or defend against your claim. And you have to keep in mind that once that recorded statement is given, that's permanent. You can't unsay something. And that's one of the biggest problems, that people are often to give a recorded statement before they know the full extent of their injuries. Before their neck might be sore, their back hurts, maybe they think they'll be fine in a few days, and then it turned out they need a bunch of treatment. But then the statement you gave on day one does not really reflect how you feel on day 30. That's why I generally tell people not to give a recorded statement to the other driver's insurance company, especially before speaking with us. A short conversation today can prevent a lot of problems later. So when the insurance company calls, talk to a lawyer first.
People are not sure whether the rules are different with their own insurer. So, what about your own insurance company? Do you have to cooperate with them?
Yes, I would say to cooperate with your own insurance company. Before you cooperate with them, of course, speak with a lawyer, but then also what we do is we ask them to provide the policy language that states what their obligations are as they're insured. And I think, yeah, it's really important to, when you're dealing with other drivers, insurance company, you want to be very careful, but your own insurance company is very different. You have a contract with them, and that typically requires you to cooperate with their investigation. You bought insurance for protection, but that protection also comes with responsibilities. That doesn't mean you should just blindly agree to everything they ask for. It just means that you shouldn't ignore them. If it's a property damage claim, failing to cooperate can cause really big problems, and in some situations can even jeopardize your coverage. So it's really important that you get to cooperate with them and find out what the policy language says, because the goal is to protect your rights without creating unnecessary problems. When it's your insurance company, cooperation is usually required, and the key is just doing it the right way.
So, timing protects your evidence and your deadline, and knowing who to talk to protects your words. So, let's close on the things clients worry about most once they have actually hired someone. So, people expect hiring a lawyer means endless homework on their end. What does the client actually have to do once a lawyer takes the case?
Clients actually have to do a lot less than most people think. And a lot of people worry that hiring a lawyer means that signing up for a second job, and that's usually not the case. Our job as lawyers, our job is to handle the legal work, and the client's job is just to focus on getting better, which is what you would do whether or not you pursue a case. So there's things that clients do that do make a big difference, and let me explain this. You need to get the medical treatment that you need. You need to follow your doctor's advice, keep us informed about the changes in your condition. And then if we ask for information, just provide it to us. And the better the information, the better that we can tell your story to the insurance carrier or to the jury later on. If you're missing work, keep track of it. If your injuries are affecting your daily life, tell us how. If you can't do the things that you used to do, that's really important information. The medical records, they tell a part of the story, and you tell us the rest. At the end of the day, the best client-lawyer relationships are partnerships. We handle the legal side, you focus on your recovery and keep us informed. Your job, again, is to get better, and our job is to handle everything else.
People have heard horror stories about lawyers who go silent for months. How does a lawyer keep a client updated through a long case?
Communication with your lawyer should never be something a client has to chase. At our firm, Garcia Law, we communicate every which way: phone, text, email, whatever method works best for the client. And I think what's most important is that we are very proactive. Good communication isn't just returning phone calls, it's making the call before the client feels like they need to. And that's really our goal, that's our mission. No law firm is perfect, but one of our commitments is that if a client reaches out to us, we get back to them within 24 hours. Because one of the most frustrating feelings is wondering what's happening with your case. And clients, they shouldn't have to guess. Even when there's no major update, people deserve to know where things stand and what we're waiting on and what comes next. A personal injury case, it's a big deal to the person living through it. And good law firms should never lose sight of that.
People worry a lawyer might just drag things out to run up value too. So will hiring a lawyer slow the case down or speed it up?
Usually neither slow down nor speed it up. The biggest factor in how long a case takes is not the lawyer. I think it's the injury. A good lawyer, we're not trying to make the case take longer, and we're not trying to rush it either. The goal isn't to settle fast. The goal is to settle right. And one of the biggest mistakes people make is focusing on speed instead of value. If you're still treating, still in pain, or still figuring out the full extent of your injuries, settling early, that can be a really expensive mistake. I've seen people accept money before they knew how badly they were hurt, only later to find out they need more treatment. And then again, unfortunately, once the case is settled, it's over. That said, a good lawyer they often help avoid unnecessary delays by gathering records, communicating with the insurance company, and just keeping the case moving forward. And the goal is to keep the case moving as quickly as possible, but not any faster than the facts allow. And most clients, they don't care whether the case settles in 6 months or 8 months. They care whether they receive fair compensation. And fast is only good if it's also fair.
The biggest fear for a lot of people is that calling a lawyer guarantees a courtroom. So will going to a lawyer mean the case has to go to court?
No, hiring a lawyer does not mean that your case has to go to court. And the most personal injury cases, they never go to court. A lot of people call us, they're worried that they'll have to testify in front of a jury or spend years fighting a lawsuit. Most of the time, that's not what happens. Most cases, they're resolved through settlement. And one of the reasons cases settle is because the insurance company knows that there's a path to court if they don't make a fair offer. The goal is not to go to court. The goal is to get the best result possible. And sometimes that can be accomplished through negotiation alone. Sometimes a lawsuit needs to be filed. And very occasionally, a case needs to go all the way to trial. But trial is usually the exception and not the rule. So I tell clients not to think of court as the goal or the problem. It's simply like a tool. That's a tool available if the insurance company, if they refuse to do the right thing. So going to court is a possibility, but it's by no means a requirement. The question really isn't whether a case will go to court. The question to me is, what's the best way to maximize the client's recovery?
Then this is the bottom line question everyone is really asking. Is it worth it after the fee and costs? Will I really come out ahead with a lawyer?
To be straightforward with you, sometimes yes, and sometimes no. Sometimes it is worth hiring a lawyer, and sometimes it's not. The best way to find out is to call a lawyer, and to call a lawyer who's willing to tell you the truth and to be straightforward with you. Don't try to answer that question by yourself. Pick up the phone and call a reputable personal injury lawyer, a lawyer with a good reputation, good reviews. Consultations will probably be free. And a short conversation could save you from making a very expensive mistake. Again, I've seen so many people accept an offer because it sounded fair, and then only to find out later that they settled too soon or left money on the table. Most people have never handled a personal injury claim before. They don't know what the case is worth, what problems might arise, or whether the insurance company is even making a fair offer. In fact, sometimes we tell people that they don't need us. Other times we see issues that could cost them money if they're not properly addressed. The real question isn't whether the lawyer gets a fee. The real question is whether the lawyer puts more money in the client's pocket after the fee. And that's, to me, is the calculation that matters. At the end, hiring a lawyer it's an investment, and like any investment, it only makes sense if the value of the investment exceeds the cost. The best lawyer isn't the cheapest lawyer, it's the lawyer who creates the most value for the client.
People might be nervous about that first call because they don't know what it involves. So what happens in a free consultation with a car accident lawyer?
A free consultation, that's your opportunity to get answers to your questions. We'll talk about what happened, we'll hear you out, your injuries, what insurance issues there might be, and just really any questions or concerns that you might have about your case. Our job is to listen, gather information, and really hear you out and help you understand what your options are and give you, I think, the peace of mind that you're looking for. So that 10-minute conversation, or maybe hour, however long it takes, that can really save you from making a very, very expensive mistake. We'll explain what we see, what challenges may exist, and what we think the next steps should be. And sometimes that advice is surprisingly very simple. And again, sometimes we tell people that they don't need a lawyer. The goal is not to pressure anyone to signing up. The goal is really to give people the information they need to make the decision that's best for themselves and their family. A good consultation really gives the client, gives them clarity. So like with us, whether you hire us or not, you should really walk away with a better understanding of your rights, your options, and really, what your case might be worth. When it comes to an injury claim, good decisions usually start with good information. So we like to give that information to our potential clients. Again, the consultation is free, and the right advice can be priceless.
That covers when to call, how you pay, and what to expect. So let's leave folks with the one thing to remember and how to reach you. So, Lem, for someone in West Covina who has just been hurt in a crash and is on the fence about calling a lawyer, what is the one thing you want them to remember?
I want them to remember that by calling us, they're making a right decision, of course, that they'll get their answers to their questions. And we really, from top to down, from everyone in the office, we want to give them the peace of mind and guidance that they're looking for so that they can really make the best decision for themselves and their family.
If you have been injured in a crash anywhere in the San Gabriel Valley, the consultation is free and you owe nothing unless there is a recovery. So call Lem Garcia and the team at Lem Garcia Law at 626-337-1111 or reach out anytime at www.lemgarcialaw.com. Thanks for listening to Car Accident Playbook. We will see you on the next episode.